let's start the conversation with a couple of other people that are here. And so Veronica Williams and I'm missing somebody. Christina. What's your take on what you've heard today and what you know from your own experience in these cases? And folks, if you've got questions, put them in chat and or comments. No.
Okay, hello everyone. Can you hear me okay?
Yes, you're fine.
Okay, I'd like to thank the host and the panel. I'd like to thank Betsy and Kirsten and Keith for the information that you have given, because it was very informative, and all of the highlights are true. From my own personal experience as to the presentations that was presented, I want to say that the trauma involved is most intense with our youth and our young people and our adults, and they do not often understand the proceedings as much as they would in person when it comes to having that attorney privilege, information at their fingertips. And often lawyers, when they're in a court proceeding, have immediate access to information that they can easily access. And they don't often can do that when they're working remotely. So then oftentimes things are put on a continuance, and then the client is sitting and waiting to hear back as to what's going on. This affects families, this affects the child, because they're sitting and not knowing and what's going to happen next. So they're sitting and say, who do I talk to? Because they don't have access, as it was stated, to technology information. So they're sitting in limbo, wanting to know what happens next. And then also they do not have the understanding of what it means to not say anything, and they're often talking to others in the detention center, and often information gets stated that should not get stated, so they don't know really who to talk to. The privacy is also an issue that comes up. There is no privacy when they're doing remote hearings. There are distractions, as it was stated. When it comes to technology, the technology is often not there. They're often don't have access. They don't know. They don't even know how to use the technology. And so that's more stress on how to navigate into a system that's already broken. So from my personal experience and to ones that I talk to, they're sitting in limbo. So access to virtual hearing, I'm not saying it's all bad, but it does need to get better. And as Kirsten said, be ready. Have that information at your fingertips so that you know what you have to do and be aware of what's going on, the surroundings, so that you are informed and you know what's next. Because when you don't know, you're just sitting there not knowing, and then things may get stated that shouldn't get stated, and then that's another whole different conversation. So I just want to say that it can be effective, but we must do better, and how that affects the community, how it affects family, how it affects the children, and moving forward, what can we do? And we have to make our best. So with that said, we must continue to show up, stand up, and speak up, because that's the only way it's going to get done and resolved. And so, and especially during this pandemic, because of the situation and not having access, and everyone is in limbo sometimes, not knowing, we have to make this information process, at our fingertips, and let it be known how to get access to that information.
Here in Maricopa County, I practice strictly juvenile delinquency law. And in Arizona, we did not take the pandemic seriously at all. We were shut down for maybe 3 weeks, I think, at the most. We opened bars, I think, April or May. And yet juvenile court is pretty much 95% at least virtual. And what I don't understand is you're still struggling to get the judges to understand that this is important. And what ends up happening is we usually do get the in-person appearance, but the kid starts getting nervous. Why is my lawyer getting, upset? Why is there this big deal about everything? And then they start like backpedaling. Okay, well, I don't need to have my hearing in person. So what I try to explain to the courts, when you put up, all these barriers, the kids start thinking, did I do something wrong? Am I not going to get a fair outcome? Is something bad going to happen? Did my lawyer piss everybody off? So it's like a never ending cycle. So I really don't get it. I mean, we have no mask mandate. I don't think we've had a mask mandate in, I think we ended the mask mandate in April for anywhere. And I think even then it was not, even held. So I'm really still struggling how to, even as a supervising attorney here, meeting with the judges, we are basically on a case-by-case basis. The rule in place says the hearings are in person, presumed in person, yet they're not in person. They're only in person in theory. I really don't understand. I'm well aware that I think the judges are traveling because they don't appear to be in the same places all the time, yet all of our kids are in jail still, and it's just having basic hearings, even if they are just substantive procedural. Most of these kids don't even understand what court is, because now we've been in the pandemic so long, all those kids that knew about before have circled out, they've turned 18. So now the kids, they don't really know the difference. When I'm trying to convince them, hey, we need to do this. This is why it's important for me. And so I really, it's always like, well, we'll table that. Well, we'll see how the numbers go. We'll do that. It's still really, I mean, we've got problems all around, but I mean, this is like the number one problem we have right now.
Oh,
If I might,
yeah, John, please.
uh,
Right here.
first off, I give you a little background. I am a trial lawyer, far more than academician, and as such, I deal with the day-to-day reality problems. And virtual has been a huge problem. And as they've observed, it's a huge problem on two fronts, both virtual in communicating with client and virtual in terms of hearings. And they both present different problems, but they all present the same problem that nobody has mentioned. And that is, and I am far from tech savvy, but you have to understand the system you're on. We've found out that while we thought, even if we went through the trouble of going to a private room to talk to a client, we were talking on an internet network that belongs to Madison County, Illinois. There are 14 people down in our IT department that have absolute access to anything that goes on in that IT system. And so while we think, okay, the cop can't hear us, okay, the judge can't hear us, okay, the prosecutor can't hear us, we found out that every phone call was being recorded, unbeknownst to us, just as they would record them from the county treasurer's office, the county auditor's office, everything was being recorded and saved. And the way this all came to light was in a hearing, they were offering recordings of my client talking to his parents about, well, that witness won't show up, blah, 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 blah. You need to call them, be sure they don't show up, and stuff like that. And, how do you get this? Well, we record all this stuff. All of it? Yeah. Does that mean you're recording the stuff I'm talking about? So one of the first things you have to check is your system itself. How much confidentiality is there in the system? We ultimately entered into agreements that, if nothing else, give me grounds for a motion to suppress down the road that will prevent where the IT department says, my stuff is my property. If they record my conversation, it's my property, not the county's property. And that, so at least try to craft something so you have something down the road. In terms of what I think Caitlin was bringing up about that, I tell a story of a lawyer I respected greatly by the name of Clive Smith. He was actually, he was a British barrister who decided to come over, get a law license in America. And he traveled around the South for the Southern Poverty Research Group, representing Black people in capital cases in the South. And he told the story one night of one attorney, two defendants, co-defendants, one murder in North Carolina. And this was way back. One attorney objected to the fact that there was a systematic exclusion of Black jurors from the veneer. The other did not. And 12 years later, the Supreme Court obviously came to agree that you can't systematically do that. The attorney who objected for his client saved his client's life. The other one was executed. So my first piece of advice is object. Even if it's a pro forma objection that you know is going to be overruled, you never know when that is going to change and when that will be the hook that somebody can hang their hat on, and you will not have waived it. You know, all trial lawyers, the worst words I ever read in an appellate opinion is, he waived it, didn't object, he waived it. So even if it's a pro forma objection, object that we're doing this virtually. Now, a couple practical observations. I am of the firm belief that the first meeting with the client is the most important. That's where you start to establish rapport. That's where you start to establish credibility. That's where you start to sort out what decisions I as a lawyer am going to make in this case, and what decisions you as a defendant or juvenile are going to make in this case. And it's where you start to build trust, where you start to understand your client. That's, again, never, if at all possible, do those virtually. Do them in person. You got to establish it. You're talking to a person. The same goes in terms of establishing that personalness when you're doing virtual hearings. I am probably one of the more liberal people you'll ever meet in your life. I can put criminals in jail. I find it very difficult to put people in jail. And we've all been raised on TV. We see characters. We see, you know, the Perry Masons and the Matlocks, and we see Alan Alda as Hawkeye Pearson MASH episodes and people in more recent shows. We know that those aren't real lawyers, those aren't real doctors, those aren't real bad guys. When the judge sees a flat screen defendant, he becomes a character, not a person. And as I said, it's easy to put non-people in jails. It's more difficult to put people there. And another reason to really fight over certain hearings, sentencing hearings, dispositional hearings, hearings, the actual trials where they're judging credibility, is that you don't want the judge watching this like he does his favorite sitcom at 8 o'clock at night. You want him watching like he does when he was sitting on the bench 4 years ago, actually hearing cases and seeing really real live breathing people. I have yet to figure out a way in my dealing with clients to substitute sitting next to them. I can't lean over and sit when the witness says something that just comes out of, you know, blue. You'd lean over, is that true? And your client will give you a nod, what, yes or no or something, you know, you get a feel. Are the client's acting up? I could just press my leg against his leg under the counsel table and shut him up. Or get him to quit rolling his eyes or huffing or whatever in the hell he was doing at the moment. That is lost in virtual hearings. We have to, you know, the pandemic is a pandemic, we've got to live through it. But I am confident that one day this is going to be back to where we can do real live hearings with little to no risk. And we have to fight to maintain every bit of live, in-person feel, touch, contact between our clients and prosecutors, our clients and judges, our clients, and we're going to have jury trials that way if we're not careful. Our clients and the jurors, they have to see real people, not flat screens. And so, I leave you with object. It is the job of most defense attorneys and all public defenders to throw sand in the wheels of justice. So grab a handful of sand and keep throwing.
Thank you, John. Brilliant. You're absolutely right on that.
Herschella, I think you muted yourself.
Thank you. Okay, I was saying thank you, John, for that. I agree 100%, just brilliant. And for all of the presenters, it's been provocative for me to listen to what you have to say. And when we talk about adolescent brain development, yes, that makes it harder, I think. But I think also there's certain arrogance that as adults, we are not similarly impacted by Zoom. That it really is difficult to assess the fullness of the person that's speaking or whatever. And I thought about this Zoom feels a little bit like for adults, I think, almost like a minotaur. Yes, the upper half is one thing. What's the bottom half look like? And we don't know. We don't know. And what are we doing? And several people have commented on this in the chat. Zoom also allows us to invade private space, our clients' home spaces that may implicate and trigger bias, as opposed to the view of the courtroom. And again, you can never be certain of what we are missing. You can't, you don't know if mommy is standing there with signs saying, say this, you don't know. And again, this notion of private space in someone's home, not everybody is fortunate enough to have private space in their home, especially children. And I will just admit for myself when I talk about as a defense lawyer, it's more difficult for me because I can be distracted. Because if my dog gets up, I'm distracted. Where's she going? And it's a split second and I come back to it and I consider myself a serious lawyer and a serious old human being. But for that split second, I'm watching my dog walk into the kitchen. And all of those things then impact how we process what is going on, I think, in front of us. Now, see, my phone's ringing right now. See what I'm saying? I'm not even gonna look. But for a kid to have another phone ring, is one thing. And the other thing is that when we talk about access, not everybody, this may be a shared phone. This may be a shared phone, so all of those things need to be taken into account. And someone put in the chat, and this is useful, that he was able to involve family from out of state because of Zoom. And what I've heard is that from almost everybody, I think there's agreement that Zoom is here to stay for some things. And that non-dispositive court appearances, that's fine. If it's an agreed on date, fine. We can save time, we can save, money, we can save the planet without having to drive to court. But we've got to find the proper constitutional balance and think about all of the things, and not just how our clients are impacted, but how we also are impacted by this new screen reality. So comments, questions, please feel free to,
Herschella,
yes.
one other practice cautionary tip: beware of hot mics. I haven't had this, but I had to happen to a friend of mine. Hearing's over. He didn't log off and said that, that judge is an effing moron. And it was hot.
Oh, yeah.
Be careful of hot mics. Be careful if you're talking to your client that you're sure it's you and him and not you and him in the world. Again, I'm not real tech savvy. And so I try to be doubly cautious about being sure I got the mute button on, or being sure that I'm where I think I am. And I'm not talking to 3 people when I think I'm talking to 1. We've all sent a text message to the wrong person. In a court hearing or post-court hearing, that can be a disaster. Watch out for hot mics.
Okay, yes, I agree 100%. So there's a question in the chat right now that says, Zoom wasn't built for this use. Can we establish a minimum requirement for the technology and recruit software providers to implement these added features? Thoughts on that? And I'm sort of, anybody want to weigh in on that before I say my immediate thought?
Yeah.
My immediate thought was, John, go ahead.
In Illinois, I think that's the type of thing that in the past, we need to bring up with like our administrative office courts in Springfield and at the Capitol in the Supreme Court. But I think it's an excellent idea that, we have to have standards. And quite honestly, probably most of the people on this meeting are not capable of writing. We know what we want. We have no idea of the technology that would be needed or even how to phrase it. So yes, I think that's an excellent idea, and maybe something we ought to be taking up with our individual administrative offices and the national court system.
Raise your hands, please. Dick has his hand raised, okay? And then Christina.
Do you point to me? Is that what's happening
Yeah,
here,
yeah.
Herschella?
Yep, you had your hand raised, so.
All right.
You then Christina and then Betsy in that room. Okay, go ahead.
First of all, my career was technology, so I'm not uncomfortable in this arena. But one of the things that keeps jumping out is you can't really control the physical environment of somebody calling in remotely. Maybe that's a problem. Maybe we ought to establish some environments where people could call in. Example was if the only facility at the only ability at some facility is to use a shared room, then probably we shouldn't be doing that. We should find out a way to restructure the facility to put in a room. Same thing for the point John made about the network that we're using, that others could easily. There are a lot of ways to get into your computer if you're on the same network. So it seems to me a lot of this would go away if we had periodically through the city locations that were built for this kind of thing, so that if my home is chaotic, I could take a bus 20 minutes away and get to a place that isn't. So I'm wondering whether there's some physical facility adjustments that are required in order to make this even reasonable.
Christina?
So one of the things I just wanted to weigh in on is that as defenders, we've always been incredibly creative. And what I saw during the pandemic was defenders being creative with this new quote unquote normal. And so one of the things that we did is we reached out to Melanie Foote. She is out of Kentucky. And what she did is she worked with the AOC to help build out these platforms to address some of the things that have been raised with who controls the chat, who has access to the chat, who has access to these breakout rooms. Do I want to have a separate line of communication where my client can call me on my office phone and I can mute if they have a question so that I'm not using the courts breakout room? Additionally, and I know that she would be happy, I can put her contact in the chat. She worked with a grant to make sure that the children that were in the detention center had access to iPads. And she researched how you can have an iPad that's in a case that doesn't have access to the internet, but you're able to do conversations, so that there were an increased number of iPads so that kids, so they could have contact to the kids when the detention center, this is at the height of the pandemic, when they couldn't get in to see the kids. But she's been incredibly helpful and so open about sharing the grants that they wrote and different resources. I know someone in the chat wrote that they use Blue Jeans. One of the things that Dr. Kavanaugh had talked about was when you're a defender and you need, maybe you have a code word for when your client has, the little brother come into the room. So when he says, applesauce, that you start talking about sports until you can go back to the case. But just coming up with all of these things, the way we've described it is that our ethics, our responsibility to our clients hasn't changed. The way we have to discharge those duties has changed. One of the things that I did, I was still on the front lines when the pandemic started, is that I had clients come into our conference room. So at a minimum, I was there with my client, even if I lost the battle with the courts that this plea or this hearing needed to be done in person, my client was there in the room with me. So then I could mute and have a conversation, right? I did know who else was in the room. I knew that no one was handing him notes. I could prepare him or her or they ahead of time about what this was going to look like, what the boxes were going to be, what was going on in the chat. And I think that was really helpful, because then we were on the same team. We were in the same room, and it wasn't perfect. And I think that's really the message that Kirsten brought to us, right? Like there's some aspects of it that are here to stay. And I hear what Warren's saying is that you can have, involvement from family members that maybe otherwise wouldn't have been able to be involved. You can have that and have your client there, right? Like grandma can appear from South Carolina on Zoom, but that doesn't change the fact that your client can still be next to you. And I think the idea is to take whatever things, the small kernels that have worked during the pandemic, and add them in with what we think is important that we already learned in the before times.
Yeah, and let me just say this, Christina, love the backsplash, love the countertop, love the flowers. It does make a difference in people's heads. So lovely kitchen. Betsy, you had your hand up.
Well, Christina said most of it. I mean, I think it's really important to separate out what's essential to keep as inhuman in person, and sometimes it surprises us. I remember with Priya when there were concerns about questionnaires, children in juvenile facilities, and were they being subject to sexual harassment and assault. And I remember one ombudsperson at that time, the most prominent one around the country, that started in Texas, went to Ohio, so startled because he found that even his in-person conversations with children had not been sufficient to establish what was going on. The only place children felt safe reporting what was happening to them was in-person conversations with family members. And I think we have to be so careful to not, John said it so eloquently, to not dehumanize, to make sure that our children going through the system feel that the system is being fair and respectful to them too. That's really essential as well.
Yeah, anybody else? Raise your hand, please. And look. Okay, Christina, your hand's up. Go ahead.
So one other thing that Betsy raised that I wanted to touch on is one of the things I think that's important when we start talking about virtual hearings and whatever pluses there might be. One of the concerns that I have is not only are our clients understanding, but that we're losing some opportunities for rehabilitation. If we really buy in and we're really committed to juvenile court is about rehabilitation and making sure that youth feel like they're having a fair hearing, and that studies have shown that youth that feel like they're having a fair hearing and feel like they're being heard, regardless of the outcome, whether or not they agree with it, they're more likely to do well in that outcome. If youth don't feel that it's fair, then it doesn't really matter how we feel about it or how judges feel about it. If youth don't feel like they're getting a fair shake at their hearing, if the studies are showing they're less likely to be successful on probation, then like what else matters? And I think about all the things that we lose. You know, when I was in person, I would hand clients and hand their parents copies of my business card. I would put where they could contact me. They had my email address. They knew, you know, where to contact me after hours if it was an emergency. I gave them the numbers to probation. I gave them the numbers to the court if someone woke up with the stomach flu and they needed to change their court date. That is lost in virtual hearings. And so I would have clients calling me saying, you know, what's my probation officer's name? How long do I have to be on probation? What's the address? Like all of these things that just happen, wrote automatically in person, aren't happening online. And I think that there's just so many times that we don't realize how much more we were doing that we're losing when we have virtual hearings. And a lot of that is the paperwork, is the tangible copy of all the conditions of probation, is the address, is the phone number. And all of that backup, which is lost in virtual hearings. And at the end of the day, if that's going to impact whether or not these kids do well for the rest of their life, if they do well with rehabilitation, if they do well with the services, then that's the entire point. We've gutted the entire reason that we have the youth justice system.
Yeah, I agree with that wholeheartedly. And let me say one thing. I think this is the tension of being a defense lawyer, especially a juvenile defender, is that what we want is the best for our clients. And so we are making recommendations about how to make virtual court fairer and more accessible. The other side of that tension, though, and this is where Rekowski comes in and resonates for me. I'm torn between making a better mousetrap. You know, I don't want to help necessarily put in place those things that the courts might find sufficient to overcome what I hear is our strong opposition to virtual hearings when any serious issue is being debated, or there's a trial, or there's witness testimony or anything like that. So I think we've got to be very thoughtful about procedural minimums without capitulating that the best procedure would be to not allow anything that will impact the case significantly to take place, you know, on Zoom. Because again, as we can see, you know, I miss the hands that are raised, so I'm going to shut up. Veronica and then Dick. Go ahead, Veronica. You're muted. You're still muted. Veronica, you're muted.
Can you hear me now?
Yep.
Can you hear me?
Yes.
Okay, I just want to chime in what Christina said, and remembering that we are dealing with children, and the mindset of children are emphatically different than adults, and that when they are dealing with court hearings and proceedings, that we have to understand that they are fragile. And when they become fragile, they can become disorientated. And if we're not careful, we lose them in the system. And oftentimes what happens is that they go through a process of wanting to harm themselves or hurt themselves because they have no contact. So this is why it is so important to deal with it from the standpoint that they are fragile and that they are children. And it's a mindset that we're dealing with, that they are children. We have to be very careful of that because we can lose them at any moment, at any given time.
Yep. Dick, your hand's raised.
Yeah, I just, as I listen to this, obviously the sentiment, people don't like virtual. However, when I looked at the percentage, I think it was the defense attorneys, 5% of them thought it was a good idea, and but 73% of the judges, I don't remember if my numbers are correct. But it seems to me that whether we like it or not, it's going to be a continuing attempt to get established. There are forces that want this to happen. So I think we ought to spend some time seriously talking about what it is we would like to have in any virtual explanation, including which one should never be virtual. I just think that you sort of have to deal with reality here. I mean, I may not like it, but it's better to control it than try to oppose it.
No, I get that, and I agree with that. And there, again, you know, like I say, if we know ahead of time this case is going to be continued, discovery is still outstanding, then fine. I don't need to drive to court to get that. I can let my client know that ahead of time, so they don't have an expectation of being there. I can let them know that there's nothing that will determine the outcome of your case that you will not be aware of. And I think that's right. We're not going to ever again be Zoomless, okay? It's here and it's here to stay. But again, we've certainly got to also say where we think the line has been crossed. Because I think people can put their toe on that line, and the next thing you know, we're in big trouble. Let's see. So Luis is saying you guys can get a copy of the recording. Just send him an email to that effect. Any other questions, comments? John?
I just want to make one observation to personalize this to the people who are with us today. And that is, in a few minutes, we're all going to click leave. And this is going to be over and we're all going to go about our business. What we have lost, one of the things we've lost in virtual is when I'm talking to a client in person and I'm done talking to him, I'm still going to spend 10 minutes with that client talking while the guard comes and lets me out. At the end of a hearing, I'm going to spend 10 minutes talking to the prosecutor, not on the record, as we pack up our files and we walk out of the room and we're actually still sometimes negotiating cases. That is what one of the big things we are losing in terms of building rapport, building the kind of contacts that you need to effectively represent your client. It's the fact that when we click leave in virtual hearings or virtual meetings, we leave.
You know, that I had made a note here to myself about auxiliary services and providers, and this piggybacks on what you just said. Two things. One, we now in Zoom, we all want to know what kind of dog you have. And the second more important thing is you don't on Zoom establish those other relationships necessary sometimes for good outcomes with probation officers, with mental health assessors, with the clerks. Come on now, you gotta know the clerk, okay? You know, and all of the providers and all of the players in these scenarios, the sheriffs, all of that can impact better outcomes for your client. And you just cannot get that on Zoom. And what you get on Zoom in lots of courtrooms that I see is a real structuring of power, you know, because some judges, you can't get in the courtroom early unless you put attorney in front of your name. So, and those types of things, you know, and again, where do you know the rules? So you've got these people, and this is an adult court, which I see as violative of an open courtroom. I get it in juvenile, but yeah, I think your point is well made on that score. So, and what kind of dog do you have?
6 grandkids, 3 of whom I have locked out of the room right now.
Okay, all righty. Any other comments, questions, suggestions? Folks? Okay, so let me just end with this. Thank you all for coming. We had a good turnout. Again, and if you want the recording, you can pick it up and feel free to share. I'd like to thank all of our panelists for taking the time to speak with us and framing this in context and allowing us to have these types of conversations. And, you know, if there is some other topic that you want to hear about from JJI or that you want to share, please let Luis know. We will put something together as soon as possible. And so I thank everyone who does this work and who supports this work for spending this afternoon with us. We are probably going to be down until next year. So happy holidays and good health to everybody. You know, and with that, if there are no other questions, again, thank you for the time and consideration that you have given to these issues. Keep fighting, stay in the struggle, and stay strong.